Hello, everybody. This is immigration attorney Irene Weisman. Today is again Wednesday, August 13th, 2025. Just wanted to do a different segment. Just did one on Department of State human rights reports that just came out. I want to do another one. This is something that I alluded to a few days ago when I did a segment. So there is a new policy with USCIS regarding the standalone I-130 immigrant visa petitions. Okay, this is your underlying petition for any family case. Okay, what is USCIS saying? They're saying that in plain language, if you don't have status, you could be detained, basically, and placed in removal proceedings. But in reality, what I think it's saying is that if it is a standalone I-130, okay, and there is no basis for a 485 application, and if it's a standalone I-130, and you entered without inspection, okay, and the goal was to, some people did it just to have it, and most people in the last 10 years or so, maybe more, 13 years, did it for the purposes of subsequently filing a 601A waiver. I think that's going to be risky going forward, okay? It's very difficult for the government to get rid of the 601A because it's, again, it's in the regulations. So I think, changing the policy with how they process the I-130 and who they put in removal proceedings, I don't know what they're trying to do, but I guess they're trying to prevent people from filing these petitions because people would know that they're going to be placed in removal proceedings. And that's very unfortunate, okay? So it becomes even more important to have an attorney. It starts with a very thorough consultation. Is it even worth filing? What can happen? What you should expect, okay? So, not a paralegal, not a notario, not a friend of the family, okay? Not a tax person, not the, family general attorney, an experienced immigration attorney who knows what's going on, okay? I'll be frank with you, as an experienced immigration attorney, it's very difficult to keep up with what's going on and understand everything that's going on because things change on like daily basis, okay? Even case law, recently just contradicts itself. Even the recent decisions, okay, they just contradict the precedent and what they've just decided. So just keep that in mind. But another thing that USCIS did with this memo, they clarified instances where they said that an interview will be issued and required, basically in which situations they're going to call people in for a standalone I-130 interview. And, basically they're saying when you didn't submit adequate documents to show the bona fide nature of the marriage, when there is a very large age gap, when they see that there is a discrepancy in the record, maybe there was a previous record, like a previous file, and or they see discrepancies in the current file, okay, maybe discrepancy in the information on the forms and the documents, or something that was previously filed. Remember, they have that, okay, and they review everything, and if they see discrepancies, obviously if they believe there is fraud involved, if there was a previous petition and the previous petition was denied or revoked, there is going to be now an interview. If the petitioner, the person who is the U.S. citizen or the green card holder, if they filed the same petition on behalf of somebody else, they're saying there will be an interview. If the marriage happened while if the marriage happened while the beneficiary was in removal proceedings, okay, that will now be. That has always really been the case, although I shouldn't say always. I've had plenty of cases where my client was in removal proceedings and we provided the bona fide marital exemption and it was approved without an interview. I had my own fair share of those cases, but for the most part, usually when somebody is in removal proceedings, you should expect an interview on that I-130. Let's see. If there is a previous asylum case and they see, they're seeing that there is possible fraud issues, okay, there could be an interview. Let's see. I think that's about it. So, a lot more cases will be going for an interview, and just keep in mind, if you don't have a lawful entry or if you don't have an immediate pathway to a green card, chances are you will be placed in removal proceedings. Whether they're going to detain you or not, I don't know. I think you would have to look at other factors, but I think you can definitely expect to be placed in removal proceedings, okay? So that's the new USCIS memo. And again, if you are in this position, if you're thinking to file a case or not, maybe you've already filed a case, okay, and your documents are pending, schedule a consultation. Okay, everybody, have a good day, and I will talk to you soon.